Okay, blessings, fam. This is a BG2G commentary on the monumental reversal of Roe versus Wade. This was a decision made June 24th, 2022. So I am so excited to be breaking this down. Mississippi's Gestational Age Act provides that, in quote, except in a medical emergency or in the case of a severe fetal abnormality, a person shall not intentionally or knowingly perform or induce an abortion of an unborn human being if the probable gestational age of the unborn human being has been determined to be greater than 15 weeks. Okay, so this was Mississippi legislation, an act that they enacted, and that's the language that is basically being contested in this case. And so the respondents is Jackson's Women's Health Organization, an abortion clinic, and one of its doctors challenged the act in federal district court, alleging that it violated this court's precedents, establishing a constitutional right to abortion, in particular Roe versus Wade, and Planned Parenthood of southeastern Pennsylvania versus Casey. So those are two different monumental cases that one, Roe versus Wade, created the whole thing, and then Casey kind of like affirmed Roe versus Wade. The district court granted summary judgment in favor of respondents and permanently enjoined enforcement of the act, meaning the Roe versus Wade, reasoning that Mississippi's 15-week restriction on abortion violates this court's, meaning the Supreme Court, the U.S. Supreme Court, violates this court's cases forbidding states to ban abortion pre-viability. The Fifth Circuit affirmed, before this court, petitioners defend the act on the grounds that Roe and Casey were wrongly decided and that the act is constitutional because it satisfies rational basis review. Okay. So in summary, what the court today, as of June 24, 2022, held is that the Constitution does not confer a right to abortion. Roe and Casey are overruled, and the authority to regulate abortion is returned to the people and their elected representatives. Okay, so every state is capable of creating their own laws, but then at the federal level, it's this general understanding that all states have to obey. So by overturning it at the federal level, they are returning the power back to the states to make a decision. Each individual state can have now and create different rules regarding abortion and the laws. So they did not abolish it. They gave freedom back and choice back to the individual states so that people can wrestle and debate this with your legislators and things like that, okay? The critical question is whether the Constitution, properly understood, confers a right to obtain an abortion. Casey's controlling opinion skipped over that question and reaffirmed Roe solely on the basis of stare decisis. A proper application of stare decisis, however, requires an assessment of the strength of the grounds on which Roe, that's the Roe versus Wade case, was based. The court therefore turns to the question that the Casey plurality, and they'll define it, did not consider. One, first, the court reviews the standard that the court's cases have used to determine whether the 14th Amendment's reference to, quote, liberty protects a particular right. The Constitution makes no express reference to a right to obtain an abortion, but several constitutional provisions have been offered as potential homes for an implicit constitutional right. Okay, so Roe versus Wade held that the abortion right is part of a right to privacy that springs from the First, Fourth, Fifth, Ninth, and 14th Amendments. Okay. The Casey court grounded its decision solely on the theory that the right to obtain an abortion is part of the liberty protected by the 14th Amendment's due process clause. Others have suggested that support can be found in the 14th Amendment's equal protection clause, but that theory is squarely foreclosed by the court's precedents, which establishes that a state's regulation of abortion is not a sex-based classification and is thus not subject to the heightened scrutiny that applies to such a classification. Rather, regulations and prohibitions of abortion are governed by the same standard of review as other health and safety measures. So let's look at the constitutional amendments that they're talking about. So Amendment 1 is Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So basically, you know, whether you have can have an abortion is something that is a grievance. We have a nation, we are divided. There are people who feel that having the right and not going to jail for exercising that right is very important, and other people who feel that, you know, it's morally wrong, and so people should not have that right, or at least the right to access those types of criminal treatments or like cruel kind of like evil procedure, such as killing babies, right? So it is a grievance, and it is a grievance that has legitimate concerns, valid arguments on both sides, and so it has a right to be addressed through government. Okay, so that is the Amendment 1. Amendments 4th and 5th are here, and the 4th says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. So basically, I would say that Roe versus Wade in the 4th Bill of Rights, they're basically saying the argument is that, you know, a woman who's pregnant, or maybe in an unwanted pregnancy, should have a right to feel secure in making decisions or hiding that pregnancy or not wanting it. And those conversations should not be public. They shouldn't be, they should feel safe in making these things without the fear of unreasonable search and seizure, or like a violation of their privacy, because it's such a huge decision. They should be able to feel secure in existing with that pregnancy until they decide what they want to do with it, even, terminating it. And then Amendment 5 of the Bill of Rights states, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land of naval force or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So under this, because the problem is that there's a demand. There are women with unwanted pregnancy that see the burden. They don't feel qualified to address the burden. They want to terminate the pregnancy. This has happened, and even when the laws were like criminalizing this behavior, people are doing it. People were leaving their babies in dumpsters. It was really bad. It was, people have been making this decision to abort or abandon their babies and not take care of it for a long time, So if it's criminalized, then due process should be done. And having a baby does deprive you of life and liberty because it is a huge responsibility. So with that said, it falls under somewhat, ambiguously or implied on in the Fifth Amendment that, there should be a due process of law, that government has a right to try to legislate or kind of mitigate the argument, and because it does affect life and liberty, and that people should feel a measure of safety in making these decisions, especially, and women and pregnant, and it shows, and it's a matter of what would be otherwise an infamous crime, right? Like if abortion becomes illegal, it would be an infamous crime because people know, oh, you're pregnant, oh my goodness, right? It can show after a certain length of time. Amendment 9 states the enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So basically, it's stating disparage means to regard or represent as being of little worth. So basically, the enumeration of the Constitution of certain rights shall not be construed to deny or regard as being of little worth other rights retained by the people. So they're basically saying that the right, whether to carry a pregnancy or terminate it, is another right of the people, right? Whether to choose life or choose death, or, even choose personal autonomy, making decisions for your own body, which a pregnancy kind of definitely overrides that. It's like, and then at the core of this is the 14th Amendment. So the 14th Amendment states in Section 1, it's the only relevant piece, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. And so this is where abortion has this plurality or this dual reality, right? Because in our laws and in life, right, we recognize that in a pregnancy, you are no longer one person, you are two lives. And so which life is more valuable, right, in the case of choice and preference is a huge is a matter of huge debate, especially when the mother who is carrying life number two, does not value it or is fearful of the consequences or of the long-term effects of that pregnancy, of that second life, and their liberty or their ability to prosper and things like that. Okay, which carrying a life, there's responsibilities. It is a burden, especially within complicated situations like, single mother homes or, or sometimes even the mother. Lately, there's been more mothers that are abandoning the children with fathers. So this is an issue. But who is qualified to determine whether in a pregnancy, whose life is more valuable, the baby or the mother, and both are equally valid. Both the mother and the baby are equally important, but there's this, paradox here in this situation. So this amendment does protect the mother, right? And a lot of these decisions and the decision to have an abortion are rooted in a lot of these, this is, life and death decisions and long-term consequences. Those are the critical constitutional provisions that are being debated and discussed in this case and in this opinion. So continuing with the syllabus. Next, the court examines whether the right to obtain an abortion is rooted in the nation's history and tradition, and whether it is an essential component of ordered liberty, end quote. So ordered liberty is like an idea or a concept or a philosophy, so to speak, in law. And so they have it in quotes. The court finds that the right to abortion is not deeply rooted in the nation's history and tradition, which makes sense. The underlying theory on which Casey rested, that the 14th Amendment's due process clause provides substantive as well as procedural protection for liberty, has long been controversial. The court's decisions have held that the Due Process Clause protects two categories of substantive rights: those rights guaranteed by the first 8 amendments to the Constitution, and those rights deemed fundamental that are not mentioned anywhere in the Constitution. So they do recognize that there are like implicit rights that maybe are not, expressly written in the Constitution, or like labeled, listed verbatim. In deciding whether a right falls into either of these categories, the question is whether the right is deeply rooted in our history and tradition, and whether it is essential to this nation's scheme of ordered liberty. Okay, the term liberty alone provides little guidance. Thus, historical inquiries are essential whenever the court is asked to recognize a new component of the, quote, liberty interest protected by the Due Process Clause. In interpreting what is meant by liberty, end quote, the court must guard against the natural human tendency to confuse what the 14th Amendment protects with the court's own ardent views about the liberty that Americans should enjoy. This is huge that this is even written here. This is so awesome, right? Because if we want a government that we can control, which is what a republic is supposed to be, we the people retain supreme rights, then these systems of government, including the judicial branch, has to be limited in its power and in its scope. And the way you limit the power of judicial and how it's prescribed to be limited is that the court, even in their opinion, is subject to the law and its precedents. And so you cannot basically create new laws through the judicial process. The creation of laws is developed expressly through the legislative branch, where you get to argue and deal with that. But the judicial branch has limitations, and in those limitations, they are not to impose their own ardent views about the liberties, their, kind of like their opinions on what liberties Americans should enjoy, right? They are basically servants of the letter of the law and applying it appropriately as it relates, especially supremely, to the Constitution. They cannot exceed the provisions of the Constitution. They are limited by it. And at the federal level, they are more limited than at the state level. At the state level, you retain more freedom and more variety. But at the federal level, because it affects all 50 states and those in the union, it has to be acceptable to all 50 states and those in the union. It has to be the greater majority of all states and its people before it's okay for the federal level to put a stamp on it. So, and it'll get into this. This is so good. This is like, yes. For this reason, the court has been reluctant to recognize rights that are not mentioned in the Constitution, right? So if it doesn't say, in the Constitution, abortion is a fundamental right, it's not expressly written, then the federal government is limited in like, we cannot say it is a fundamental right. Okay. Guided by the history and tradition that map the essential components of the nation's concept of ordered liberty, the court finds the 14th Amendment clearly does not protect the right to an abortion. Until the latter part, and I just want to throw in here for anybody who's cringing already, it doesn't protect it, but it doesn't prohibit it either. Okay, so until the latter part of the 20th century, there was no support in American law for a constitutional right to obtain an abortion. No state constitutional provision had recognized such right, so it wasn't recognized at any of the state levels until a few years before Roe. So a few years, okay, it was. No federal or state court had recognized such a right, nor had any scholarly treatise. Indeed, abortion had long been a crime in every single state. At common law, abortion was criminal in at least some stages of pregnancy and was regarded as unlawful and could have very serious consequences at all stages. American law followed the common law until a wave of statutory restrictions in the 1800s expanded criminal liability for abortions. That's interesting, right? So, criminal liabilities, it's like if you're performing, abortions, if you're soliciting, kind of like prostitution, right? If you're caught even looking for an abortion, we're gonna, we can arrest you. When things like that started happening, people wanted to be like, wait, this needs to become law, okay? That we can have this right. It can't be criminalized. By the time the 14th Amendment was adopted, 3/4 of the states had made abortion a crime at any stage of pregnancy. This consensus endured until the day Roe was decided. Okay. Roe either ignored or misstated this history, and Casey declined to reconsider Roe's faulty historical analysis. So they gave the court some baloney, and yeah, they didn't have internet. They didn't have internet. So respondents' argument that this history does not matter flies in the face of the standard the court has applied in determining whether an asserted right that has nowhere mentioned in the Constitution is nevertheless protected by the 14th Amendment. The Solicitor General repeats Roe's claim that it is doubtful abortion was ever firmly established as a common law crime, even with respect to the destruction of a quick fetus. But the great common law authorities, Bracton, Koch, Hale, and Blackstone, all wrote that a post-quickening abortion was a crime. So basically, at the time that Roe was being debated, they lied to the court and said that, whoever the lawyer was, was like, listen, it's nowhere in common law that this is bad. Like, so, people are doing it, they don't like it. Common law really never addressed it. Like, it wasn't an issue back then, but it is now, maybe. So we're addressing it. But if you look historically, since so much access to historical documents and books and histories is available now, thanks to the internet, bless the Lord, they're like, no, actually, all the major historical authorities all state that it was a crime at some point. Okay. So, moreover, many authorities asserted that even a pre-quickening abortion was unlawful, and that as a result, an abortionist was guilty of murder if a woman died from the attempt. The Solicitor General suggests that history supports an abortion right because of the common law's failure to criminalize abortion before quickening. But the insistence on quickening was not universal. And regardless, the fact that many states in the late 18th and 19th century did not criminalize pre-quickening abortions does not mean that anyone thought the states lacked the authority to do so. Instead of seriously pressing the argument that the abortion right itself has deep roots, supporters of Roe and Casey contend that the abortion right is an integral part of a broader entrenched right. Roe termed this a right to privacy. And Casey described it as the freedom to make intimate and personal choices that are central to personal dignity and autonomy. Ordered liberty sets limits and defines the boundary between competing interests. Roe and Casey each struck a particular balance between the interest of a woman who wants an abortion and the interest of what they termed potential life. But the people of the various states may evaluate those interests differently. The nation's historical understanding of ordered liberty does not prevent the people's elected representatives from deciding how abortion should be regulated. Finally, the court considers whether a right to obtain an abortion is part of a broader entrenched right that is supported by other precedents. All right, so in this decision, they are evaluating it by precedents of the time. So, and comparing, which was how the decision should have been made in the first place. The court concludes the right to obtain an abortion cannot be justified as a component of such a right. Attempts to justify abortion through appeals to a broader right to autonomy and to define one's, quote, concept of existence prove too much. Like, it's too complicated. Those criteria at a high level of generality could license fundamental rights to illicit drug use, prostitution, and the like. What sharply distinguishes the abortion right from the rights recognized in the cases on which Roe and Casey rely is something that both those decisions acknowledged. Abortion is different because it destroys what Roe termed potential life, and what the law challenged in this case calls an unborn human being. None of the other decisions cited by Roe and Casey involve the critical moral question posed by abortion. Accordingly, those cases do not support the right to obtain an abortion, and the court's conclusion that the Constitution does not confer such a right does not undermine them in any way. Okay. So basically, here's the dilemma, right? There's conflicting law. In Roe, there was introduced this idea of potential life for what was considered a non-viable fetus, right? So if the probability of that fetus, if born today, if it cannot live, then it's not viable. Okay. And the idea of an unborn human being was basically what superseded that. Like, people thought, for the most part, before Roe versus Wade, that it was a human being, a human being. And so Roe versus Wade introduced this new term, potential life. And so the laws that were already in place historically addressed the baby, the human life, as a human, as a person. And this idea of potential life, that this blob was not really a human being at fetus stages, that it wasn't life, like, was a new concept. And so historically, there's just no basis, none whatsoever, that the courts even had any precedent that dealt with this topic. And then they go and they basically say that the court's conclusion, that just because the Constitution does not confer such a right, does not undermine it. Meaning, listen, the Constitution doesn't say you have it, but it doesn't say you can't have it. But basically, this is too big of a topic to be held at such a high level of generality. Like, this isn't a general right, okay? This is a controversial, heated debate that is too complicated and is surrounded by too much opinion. Like, this is not a general statement, okay? Or a general idea that can be easily understood by the majority, so to speak. Okay. The doctrine of stare decisis does not counsel continued acceptance of Roe and Casey. Stare decisis plays an important role and protects the interest of those who have taken action in reliance on a past decision. It reduces incentives for challenging settled precedents, saving parties and courts the expense of endless relitigation. It contributes to the actual and perceived integrity of the judicial process, and it retains judicial hubris by respecting the judgment of those who grappled with important questions in the past. But stare decisis is not an inexorable command, and is at its weakest when the court interprets the Constitution. Okay. And they list all the laws here. Some of the court's most important constitutional decisions have overruled prior precedents. Brown versus the Board of Education, overruling the infamous decision in Plessy versus Ferguson and its progeny. So, it's basically saying stare decisis it's like this really strict rule that when the court rules on those grounds, like, you're not supposed to contest it. It's like, that's it. This is precedent. It's been thoroughly reviewed and decided. But it does not mean that it's infallible, or it cannot be addressed later on. It has a function, for all the reasons that they listed, but it's also at its weakest when the court interprets the Constitution. And whenever it interprets it, it means that they're applying their understanding, right? And so if it does not expressly state it, like verbatim already in the Constitution, abortion is a fundamental right, then, that you don't have to interpret that. You're like reading it and it's like there, it's staring you at the face. But when you interpret it, and you're like, well, it's implied here and here. And when you combine these things, this is a right. right? Stare decisis is at its weakest, and that's where Roe and Casey were decided, right, under those reviews. So they're letting you know the grounds by which they have to review this again. Okay. The court's cases have identified factors that should be considered in deciding when a precedent should be overruled. 5 factors discussed below weigh strongly in favor of overruling Roe and Casey. So they're going to give you the reasons. Listen, this isn't a light decision. This is a serious decision. And these are like 5 key points in which we strongly believe these laws need to be overruled. 1, the nature of the court's error. So they're like, whoa, the court did something wrong at the time. Like the infamous decision in Plessy versus Ferguson, Roe was also egregiously wrong. That's a strong word. And on a collision course with the Constitution from the day it was decided. That is like hostility towards the Constitution. Casey perpetuated its errors, calling both sides of the national controversy to resolve their debate. But in doing so, Casey necessarily declared a winning side. Those on the losing side, those who sought to advance the state's interest in fetal life, could no longer seek to persuade their elected representatives to adopt policies consistent with their views. The court short-circuited the democratic process by closing it to the large number of Americans who disagree with Roe. 2, the quality of the reasoning without any grounding in the constitutional text, history, or precedent. Roe imposed on the entire country a detailed set of rules for pregnancy, divided into trimesters, much like those that one might expect to find in a statute or regulation. Roe's failure even to note the overwhelming consensus of state laws in effect in 1868 is striking. And what it said about the common law was simply wrong. They lied. Then, after surveying history, the opinion spent many paragraphs conducting the sort of fact-finding that might be undertaken by a legislative committee, and did not explain why the sources on which it relied shed light on the meaning of the Constitution. As to precedent, citing a broad array of cases, the court found support for a constitutional, quote, right of personal privacy, but Roe conflated the right to shield information from disclosure and the right to make and implement important personal decisions without government interference. None of these decisions involved what is distinctive about abortion, its effect on what Roe termed, quote, potential life. When the court summarized the basis for the scheme it imposed on the country, it asserted that its rules were, quote, consistent with, among other things, the relative weights of the respective interests involved and the demands of the profound problems of the present day. Okay. These are precisely the sort of considerations that legislative bodies often take into account when they draw lines that accommodate competing interests. So basically, Roe versus Wade was addressing a problem at the federal level that was not being addressed within the states as a matter of controversy. The scheme Roe produced looked like legislation, and the court provided the sort of explanation that might be expected from a legislative body. An even more glaring deficiency was Roe's failure to justify the critical distinction it drew between pre and post viability abortions. The arbitrary viability line, which Casey termed Roe's central rule, has not found much support among philosophers and ethicists who have attempted to justify the right to abortion. The most obvious problem with any such argument is that viability has changed over time and is heavily dependent on factors such as medical advances and the availability of quality medical care that have nothing to do with the characteristics of a fetus. So they're basically saying, listen, the court did not even process this like a real court, nor did they give an opinion the way they were supposed to, which is basically answering the questions why this is in the Constitution, why this argument makes sense, why there's a precedent for this, and it honors the Constitution, and how it is implicitly there. Like, the court did a poor job of explaining the why, which is a core function of the court. And then on top of that, they made provisions within the opinion directed by Roe that didn't answer all the questions and created some ambiguity, primarily around the viability of life. When Casey revisited Roe almost 20 years later, it reaffirmed Roe's central holding, but pointedly refrained from endorsing most of its reasoning. They made a judicial ruling, but they made a political rationale to not look nor endorse the reasoning behind the original, because it was all messed up from the beginning. Okay. The court abandoned any reliance on a privacy right and instead grounded the abortion right entirely on the 14th Amendment's due process clause. The controlling opinion criticized and rejected Roe's trimester scheme and substituted a new and obscure undue burden test. Casey, in short, either refused to reaffirm or rejected important aspects of Roe's analysis, failed to remedy glaring deficiencies in Roe's reasoning, and endorsed what it termed Roe's central holding, while suggesting that a majority might not have thought it was correct, provided no new support for the abortion right other than Roe's status as precedent, and imposed a new test with no firm grounding in constitutional text, history, or precedent. Okay. So basically, in the second ruling, they didn't do many pivotal things that is required by an accurate, adequate, competent judicial ruling. They basically kind of did another judicial / legislative hybrid. ruling, in that they didn't really review laws. They reviewed the matter. They decided on the matter based off of their own wisdom, not the rule of law nor precedent, and added its own kind of solution to the problem. Again, which is legislative responsibility. It is not the judge's responsibility, the court's responsibility to create new law. They interpret the law as the legislature creates it, and then compare it, or basically, assess it with its constitutional standing. And if it passes, it stays. And if it doesn't, it's overruled. 3, workability. Deciding whether a precedent should be overruled depends in part on whether the rule it imposes is workable. That is, whether it can be understood and applied in a consistent and predictable manner. Casey's undue burden test has scored poorly on the workability scale. The Casey's plurality tried to put meaning into the undue burden test by setting out 3 subsidiary rules, but these rules created their own problems, and the difficulty of applying Casey's new rules surfaced in that very case. The experience of the courts of appeals provided further evidence that Casey's line between permissible and unconstitutional restrictions has proved to be impossible to draw with precision. Casey has generated a long list of circuit conflicts. Continued adherence to Casey's unworkable undue burden test would undermine, not advance, the quote, even-handed, predictable, and consistent development of legal principles. So the workability is so important, especially at the federal level, because it has to be universally applied in all 50 states. And so basically, because the question or the solution created conflicts with people and groups in multiple states, it created basically, a flood of grievances within the federal court. And even within the federal court, it has proven to be like, listen, you just can't have a clear standard. There's too much conflict, too many, differences of opinion and preferences and doctors on this matter. Like, there's no workability to this rule that is acceptable or satisfies, the people on a grand scale on a federal level. 4, effect on other areas of law. Roe and Casey have led to the distortion of many important but unrelated legal doctrines, and that effect provides further support for overruling those decisions. Reliance interests. Okay, overruling Roe and Casey will not upend concrete reliance interests like those that develop in cases involving property and contract rights. In Casey, the controlling opinion conceded that traditional reliance interests were not implicated because getting an abortion is generally unplanned activity, and reproductive planning should take virtually immediate account of any sudden restoration of state authority or ban abortions. Instead, the opinion perceived a more intangible form of reliance, namely that, quote, people had organized intimate relationships and made choices that define their views of themselves and their place in society. In reliance on that availability of abortion, in the event that contraception should fail, and that the ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives. Okay. The contending sides in this case make impassionate and conflicting arguments about the effects of the abortion rights on the lives of women, as well as the status of the fetus. The Casey plurality's speculative attempt to weigh the relative importance of the interests of the fetus and the mother represent a departure from the original constitutional proposition that courts do not substitute their social and economic beliefs for the judgment of legislative bodies. This is the whole point, that courts are not supposed to do the reasoning and the problem solving and the rationalization that legislative bodies were created to do. Courts were supposed to interpret what was already written, and what Casey did was they created ideas and solutions that were not thought of. The Solicitor General suggests that overruling Roe and Casey would threaten the protection of other rights under the Due Process Clause. The court emphasizes that this decision concerns the constitutional right to abortion and no other right. Nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion. Casey identified another concern, namely the danger that the public will perceive a decision overruling a controversial, quote, watershed decision, such as Roe, as influenced by political considerations or public opinion. But the court cannot allow its decisions to be affected by such extraneous concerns. A precedent of this court is subject to the usual principles of stare decisis, under which adherence to precedent is the norm, but not an inexorable command. If the rule were otherwise, erroneous decisions like Plessy would still be the law. The court's job, this is so important, the court's job is to interpret the law, apply long-standing principles of stare decisis, and decide this case accordingly. Under the court's precedents, rational basis review is the appropriate standard to apply when state abortion regulations undergo constitutional challenge. Given that procuring an abortion is not a fundamental constitutional right, it follows that the states may regulate abortion for legitimate reasons. And when such regulations are challenged under the Constitution, courts cannot substitute their social and economic beliefs for the judgment of legislative bodies. That applies even when the laws at issue concern matters of great social significance and moral substance. A law regulating abortion, like other health and welfare laws, is entitled to strong presumption of validity. it must be sustained if there is a rational basis on which the legislature could have thought that it would serve legitimate state interests. So basically, it's like, listen, both arguments have rational elements to it. And the federal level is not the place to basically arbitrate what is more rational than others. It belongs in the state, that the state legislature basically is designed to argue these things and determine how relevant and how they want to, regulate these things, these concepts. Mississippi's Gestational Age Act is supported by the Mississippi legislature. Specific findings, which include the state's asserted interest in, quote, protecting the life of the unborn. These legitimate interests provide a rational basis for the Gestational Age Act, and it follows that respondents' constitutional challenge must fail. Abortion presents a profound moral question. The Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Roe and Casey arrogated that authority. The court overrules those decisions and returns that authority to the people and their elected representatives. That is the final decision, reversed and remanded.